Hi, folks. This is a little bit of a recap of some work that some people in the room have already seen. The excuse for doing that is Peter Manel, who is editing a volume that I've got a paper in that's a handbook on the law and economics of IP, and so he invited me, and I graciously was given the opportunity to try to condense and simplify 3 articles worth of work into 20 pages. And so a little bit of, that's the sort of, but a lot of that's a recap, and it's not just my work, it's an attempt to synthesize the work of a lot of the people that I was building on and that have come afterwards. On the coming afterwards is a recent piece by Abraham Bell, who's actually presenting in another room at this moment, and Gideon Parchmovsky, sort of responding to some of my work and misreading it in a way, so I want to take my chance to respond back. And then I want to point to a few sort of future directions for this project and try to get your input on that.
Let me say, there's no 20-page limit.
Oh, really? Okay.
So,
All right.
much, but in 2 weeks you'll learn more.
So let me just offer a couple of, for me, what are some of the challenges for our field in general in terms of anyone who's interested in doing the sort of economic analysis of intellectual property law, and what I think is missing, sort of holy grail. And that is that intellectual property is a policy tool. I don't think any of us, other than a strong sort of moral rights advocate in copyright, would argue that intellectual property law is the end in itself. It's a means. And it's only one of a series of available means that the government has to respond to the sort of appropriability problem, or however you want to define that problem. And we don't have a general theory that says, okay, if you're a policymaker, what's the right mix? As between tax policy, direct investment of public funds, and regulation through property rights, you know, how much of each of these and what's the best package? And so if there's time in Q&A, I'd love your sort of quick reactions about even, is it possible? Is that an impossible dream? Or if it were possible, what would the components of that analysis look like? What would you expect in that paper? Because I do think, as I've gotten closer to the policy process in DC, this is not just a hypothetical question. And I'm going to use drug development as an example. I mean, Francis Collins, the head of the NIH, is looking at what's happening in the pharmaceutical sector. What we see is a lot of consolidation because the R&D investments are not paying off in a lot of new sort of blockbuster drugs. And so we're getting investments in the sort of biosimilars, and at the same time consolidation on the sort of small molecule drugs. And Francis Collins is saying, well, maybe we ought to be shifting away from the patent system more towards a prize system to incentivize more R&D spending instead of spending on litigation against generics and marketing, which is what a lot of the branded pharmaceuticals are devoting resources to. And maybe we can better define what the targets are that ought to be the subject of those investments, because the ability to pay, which drives the patent system, has a lot of well-known distortionary impacts on what kinds of drug development get done and what kinds don't get done. So, you know, we might want to say, if Francis Collins is right, should we be looking at prizes? The prize literature suggests that a lot of people write that off immediately because it's like, oh, well, ex ante, I don't know how to set the prize. But the more sophisticated models of prizes show that you could mimic the market in certain ways and tie the amount of the prize to the actual amount of contribution that's made by the number of people using the innovation, and that there would be ways to sort of limit the risk of getting it wrong ex ante, which is the biggest risk of a prize system. But even, I had a recent conversation with someone at NIH. What is the optimal number of intramural researchers? Why not only give grants? But in fact, we do a mix. We have government employees doing scientific research on drug discovery, and we outsource it. But we don't have a good theory about what the mix is. What I'm told is that the intramural researchers can take bigger risks, can do the sort of longer term kinds of exploration that a grantee would never be willing to do because they've got to be able to show results to get the next round of grant. So that's a sort of small bore example of just more detailed analysis of that strategy as an alternative to IP that I don't see any of us doing, but yet actually could have some real world consequences in terms of innovation if that's what we were to focus our attention on. I don't know even enough tax law to be dangerous, but we certainly know how influential the tax gravity is within in the way that deals are done and the way that tax influences resource allocation in all kinds of deep and important ways. And it seems to me like we ought to be thinking about mobilizing that force more aggressively in terms of innovation policy. I haven't seen the paper that's sort of tax policy for innovation, and yet it seems to me like there's a lot of different things that we ought to be doing in tax expenditures. So direct expenditure of public funds on innovation, lots of political risk. Tax expenditures, we can hide that from the public in lots of different ways, and maybe we ought to be thinking about clever schemes to engage in that. We don't really.
So this is being recorded, and if you follow the Obamacare thing, it didn't work out well for that MIT researcher. But
well, no, that's right. But I'm just saying. Okay.
yeah, I mean, it's a problem.
Point taken. So, we don't think about the Gates investments in malaria research as in any way being influenced by public policy, but because those funds are tax advantaged, in fact, there is a public policy that's supporting those investments, and yet it's not part of any model. It's not sort of consciously developed, and to me, this is missing in our larger conversation. And it's a problem because I don't think many of us have the tax chops. So it suggests to me that we ought to be partnering with some folks in other disciplines to sort of hack on these problems. But let's come home now. So assuming some market failure, assuming that those other strategies have some role but will not occupy the field, then we're going to want intellectual property rights and how to design. So we have a standard story about appropriability, and the way I got into this was just trying to get my head around the basic law and economics of IP, and was surprised to sort of, the logic just stopped short, and I didn't understand why it stopped short. So now we have to create property rights in order to induce the investments and reward them. We recognize, all right. The only thing I threw in here is, in general, the other thing in our field is, sometimes people start with the observed facts and design their theory around the observed facts. But there are general jurisprudential theories out there that we might want to look at. So there are, Francisco Parisi has co-authored a paper purporting to say that he can give us a theory of the optimal specificity of law. So if we're going to design IP rights and there's a general theory of optimal specificity, maybe we ought to look at that. I didn't find it very useful. It tells you something about the more prescriptive you are in legislation, the less room for judicial interpretation you give, and you're making some judgment about legislators being more competent than judges to make these kinds of determinations. And we can talk about rules and standards and liability rules and property rules. So certain levels of general theory about how to fashion rules are useful, but it's not going to tell us very much about whether we want patents and copyrights as separate kinds of rights or bundled together. And so I think we need something that's a little more IP specific. So the problem we're trying to solve is based on providing incentives that aren't there because of market failure. The observed thing that we know is that the actors in the system we're trying to incentivize are coming at this system from very different places. And the level of incentive the system needs to provide to them to lure them into the innovation game and keep them there is quite different. And this is pretty well documented and well understood. So you're trying to solve a problem that's got contours that looks like this. And our current solution is a one-size-fits-all package of rights. Here, innovators, take these rights. Go have fun. And it struck me, why are we content with that? There's a mismatch between problem and solution. Or is there? So maybe there isn't. Here are, when I went looking for what's the economic justification for broadly defined one-size-fits-all rights, there wasn't one that I could find. Maybe it was there. So I ended up having to make the argument that I wanted to then knock down. So this is basically the argument, that the more complex you make the entitlements, the more difficult it is to generate the transactions that you actually are trying to generate with the IP rights. So if you think Coasian bargaining is going to take place and will be highly efficient, then in fact, these sort of coarsely defined entitlements make a lot of sense because all the refinement will be done through private ordering. But because we know transaction costs are quite high in the IP space, and certainly that there's variation there, initial entitlement allocations are going to have sticky effects that are going to distort resource allocation, and therefore we have to be more careful about defining those initial entitlements because they're going to stay in the same place. They're not going to get transferred in a pure frictionless bargain. So if that's true, then we ought to be pushing for more sort of tailoring of problem and solution. But maybe it's not worth the game. So maybe it's an administrative efficiency argument that even if where there's a mismatch and even if Coasian bargaining is not going to completely align problem and solution, you just introduce more complexity that makes the system worse. Or this one I think is actually an important argument, that there's a political discipline that comes with one-size-fits-all rights and relying on the IP strategy as opposed to some of the other strategies. And I'd be curious for the patent experts to know how many cases of corruption have we had where a patent examiner sees an application that comes in and then trades on that information in some way, sort of an insider trading problem, because for a while they're sitting on this what potentially highly valuable confidential information. And to my knowledge, we haven't seen a lot of that behavior. So I would suggest that in fact the property rights strategy and the way we're implementing it is in fact policing what might otherwise be, if we relied more on the government officials to have more discretion over who gets what rights, we might actually see worse outcomes. So there's a disciplining aspect to the way that we treat our IP rights. All right, where are we? Wow. Okay. So the argument is that one-size-fits-all creates what I'm calling the uniformity cost, modeled on Ronald Coase's social cost, and that for the reasons that we just talked about, we're going to have these problems. So that's the statement. So three basic options that are or strategies that are already in the system to try to manage uniformity cost. You can structure the entitlements as options rather than just as direct grants. So for example, the term of patents, we say it's a 20-year term. Actually, it's not. You have the option to have a 20-year patent, but you have to maintain the patent in order to enjoy the full 20 years, and most patent owners don't. So the effective term of protection is actually tailored. We could do a lot more with options. In copyright law, we used to allow people to opt in or required them to opt in and in patent law we do. Plenty of patent eligible inventions never get applied for, and so we are seeing some tailoring at the subject matter end. Where some interesting things could take place is on the scope of protection. You could define the exclusive rights as, well, all you get is the right of reproduction or the right to make. And if you want to purchase the right to use, sell, import, or et cetera, those are available at additional prices, and so we're going to force you to reveal your evaluation of your invention by sort of buying your way into the system. And that's what the Bell and Parchamovsky paper is. They suggest that my later paper, which is on the tailoring strategies, gets it all wrong, and it wasn't real, well, not gets it all wrong, but it's a very incomplete solution. And this is the cautionary tale for the junior scholars. I had what I thought was a pretty big idea. I was trying to work on the one idea per paper principle, which I do suggest that you stick with because we're busy readers. And so I broke the project up into different papers. The first paper was not as well written as it could have been, I will admit that. And it tries to state the problem of uniformity cost and then talk about the real option strategy and the standard strategy, leaving the tailoring strategy as a new paper. So they didn't read the first paper because I talked about the real options and the information forcing aspect of real options as having beneficial effects, and said, but we're not going to get all of the solution to uniformity costs through real options, and so you're going to also have to do tailoring. They then attack the tailoring paper and say real options are a better system. And it's like, no, I had real options in my full set. It's just that I broke it into 2 papers. So, cautionary tale. I mean, in theory, and theirs is a highly theoretical paper, we could do a lot of really interesting things with real options, and I'd love to see more experimentation. There ought to be more experimentation with maintenance fees and pricing maintenance fees. But as a practical policy matter, it's very difficult, and we've locked ourselves in through international treaties and other things. So we can do standards, and so Dan Burke and Mark Lemley wrote this paper called Policy Levers that talks about the different ways in which they argued the Federal Circuit was using the flexible standards that define the patent rights to in fact treat differential treatment in the scope of patent protection for software and for life sciences inventions, and then they argue that the Federal Circuit had it exactly wrong. The point, though, is that the standards, no cases are really decided case by case, right? Cases cluster, and they tend to cluster around either types of invention or within the industry. And courts could be more self-conscious about those clusters and could use the flexibility of judicial interpretation to effectively tailor along those lines. And so the argument is you don't have to do this all through legislation. You have the flexibility to state the law very generally and then have the courts do the work. And I would say, so in copyright, the scope of protection for software after the Altai case has been tailored so that there was a very dangerous case called Whelan that would have defined the scope of copyrighting software quite broadly, and then Altai sort of comes back and narrows it quite substantially. And so although it's a literary work, I would challenge you to show sort of the amount of borrowing that I can do from your piece of software is much larger than it can be from Harry Potter, for example, right? So that even though they're both subject to the same nominal standards, they get treated differently. If we were going to differentiate, then you can do it administratively, you can do it judicially, or you can do it by legislation. So tailoring is not limited to legislation. But if you're going to start from a one-size-fits-all baseline, what do you need to do to successfully argue to tailor? And I would argue first you have to show there's really a uniformity cost problem that's worth worrying about here. So I would argue that the Hatch-Waxman Act, for example, was a response to the breadth of the right of the patent owner to control use, and that use right was keeping generics off the market longer than is necessary, and Hatch-Waxman comes up with a complicated scheme by which the use right is tailored down in order to promote earlier generic entry. If you can do it, is it administrable? By this, I'm saying, can you game the system? Right now that I've created a differentiation, we know that there's going to be legal arbitrage, and then is it politically feasible? Can you actually get it done? I'm going to speed through this. These are just sort of the types of evidence that I would expect. Coming attractions. Just speed through these. Those are basically the details of the three. So the next piece I want to write is sort of the law, the international law of tailoring, because we're currently invested in a lot of treaty negotiations that are designed to lock in uniformity. And a couple of quick examples. Article 10 tells all the member states of the World Trade Organization that they can't mess with software. Software is a literary work under the Berne Convention, and therefore it has to basically be, all the rights of exclusivity have to be given that you give to novels and things. But there's a lot of overstatement about the ways in which the advocates of uniformity have succeeded. So in Article 27 of the TRIPS agreement, it appears that you can't mess around with patents, that all patents have to be treated the same regardless of the field of technology. But if you notice, what just happened? This is true for something that qualifies as an invention. So what do they do in Europe? Well, they just define what counts as an invention, and they define software and business methods out of the invention, and therefore they're not subject to the Article 27 non-discrimination principle. So there's actually more policy space in the international field to tailor, and that's what that piece will be about. All right, shoot. I talked longer than I meant to. There's a minute and 20 seconds left. Anybody want to do a quick question? Harry's fast.
Just a quick commentary. One, I think you suffered from tailoring costs and splitting up your paper.
Yeah.
Just one other justification I've seen for uniformity costs is hybridization of inventions. So if you preference one category of invention, say software, over automobiles, they say, oh, this is just a piece of software with wheels, actually. So they don't want to get into the, we do it a little bit in 101 already,
Yeah.
where like this is a product nature, but one of the arguments is the courts don't want to get into these battles where everybody starts fighting over these hybrids. And we saw this before State Street with software patents where it was a machine, and
Right.
we're sort of seeing it again.
Yeah, right. So that's legal arbitrage.
Right, right.
And we will invite it. There's
Yeah.
no question. Go ahead.
This is just giving you ammunition in your exchange with Bell and Bachamovsky.
Yeah.
So it seems that if, as you said, there's a lot of work to be done with real options, it means that the situation is really bad in terms of tailoring, because real options, can do a lot of good work, but if they really deal with extreme cases, right? Real option, when it's not worth to the patent owner to pay the maintenance fee, it's not worth to do renewal in copyright, means even privately, from the point of view of the copyright owner or the patent owner, there isn't any benefit there. We didn't even yet talk about the public calculus, right?
Right.
Which is all to say, again, options have a lot of good to do, but they deal with the really extreme cases that even from the private perspective of the owner, it doesn't make any sense.
Right.
It means, again, if in the current situation there's a lot to be done with those options, it means that we're way off the mark.
Yeah, that's a nice point. Thank you. And time's up. I apologize for missing